of the PowerPoint. And with that, it's my distinct pleasure to introduce Shirley J. Wilshire, who is the Executive Director of the American Association for Access, Equity, and Diversity, formerly the American Association for Affirmative Action. Ms. Wilshire is also President and CEO of the Fund for Leadership, Equity, Access, and Diversity. During the Clinton administration, she served as Deputy Assistant Secretary for the Ofccp, the Office of Federal Contract Compliance Programs, in the Employment Standards Administration of the Department of Labor. Ms. Wilshire has served as an Associate Civil Rights Counsel with the Education and Labor Committee, U.S. House of Representatives, Director for State Relations, and General Counsel with the National Association Independent Colleges and Universities, a staff attorney, and the National Women's Center, and CEO of Wilshire Global LLC, a diversity management and consulting firm. She has also worked as Executive Director of the Americans for a Fair Chance and Consortium of Civil Rights Organizations. Ms. Wilshire is an honor graduate of Mount Holyoke College in South Hadley, Massachusetts, holds a Master's of Arts degree from the New School for Social Research in New York, and has a Juris Doctorate from the Harvard Law School in Cambridge, Massachusetts. Ms. Wilshire is founding board member of the National Political Congress of Black Women and received the NAACP's Keeper of the Flame Award. And again, welcome, Ms. Shirley Wilshire.
Thank you, Sandra, and welcome everyone on our launch of our construction contractor training. We are delighted to have you. For some of you, you may be new to the American Association for Access, Equity, and Diversity, or AAAED, as we call it. But understand that we actually go back to 1974 as the American Association for Affirmative Action was launched. It was launched after the regulations were being promulgated for affirmative action at the Labor Department, and there were new rules at the EEOC. And so we've got a pretty long background. We believe, the longest serving equal employment opportunity organization in the United States. So we do have the expertise that we believe that you need. Now, one of the things that we also have is the Professional Development and Training Institute, which is on the next slide. PDTI, as we call it, has been the primary sponsor of quality training in equal employment opportunity and affirmative action law and policy since 1991. So we've got 27 years in this EEO training business. We offer the Certified Affirmative Action Professional and Senior Certified Affirmative Action Professional credentials. As we say, do you have your CAP? We also offer cases and certificate programs in areas ranging from diversity management and Title IX to latest Ofccp compliance developments. And of course, with Sandra Huneman, we have this wonderful webinar series, such as today's, some of which are, of course, complimentary to AAAED members. We urge you to follow up and visit our training website, training page, which is on our AAAED website, AAAED.org, and click on the training page. And I think you will see a wealth of programs. As far as I can see, the only major organization that competes with us in terms of training at this robust level is Cornell's ILR program. So we're in very good company. Next slide. Now, one of our major activities is our conference, and this year marks our 44th national conference and annual meeting. And we will be in Atlanta, Georgia, June 6th through the 8th this year. Our theme, Bridging Opportunities, Keeping the Dream Alive. For the conference, we hope you'll join us, where you meet many of your colleagues. Some of you may do only construction. Others of you may work for companies that have both supply and service as well as construction. And you want to meet other people who are responsible for affirmative action programs. Well, that's us, and that's where we are. One last thing, we urge you to join AAAED, because in addition to our programs, we have a listserv where if you have questions, further questions about compliance issues, you just send out a question to the listserv, and several people, as I've noticed, will respond to your questions. And so again, we are part of a community, and we urge you to join us. Now, joining us this afternoon for our training are three individuals whom I've known for many years, especially as I was head of Ofccp. These individuals have a wealth of knowledge. I won't say how many decades, we won't age anybody, but they have a wealth of knowledge about this. We assembled these three individuals because they know the construction compliance area. And in order of alphabetical order, I will mention Harold Bush first. He's currently the president and CEO of the Bush Group, LLC, which provides consulting, training, and advisory services in all aspects of EEO and affirmative action compliance. Mr. Bush was the director of operations at the national office when I was there. So he's been in the contract compliance profession for many years. Mr. Bush was also a mediator for the EEOC and taught at the Cornell, New York State School of Industrial and Labor Relations. He holds a BA and master's degrees from Rutgers, the State University of New Jersey. Sandra Huneman, our organizer today, as she mentioned, is president of Manchester Consultants, which provides consulting and advisory subject matter services in all facets of EEO and affirmative action compliance. I might add that she's also the regional director in the Midwest for the American Association for Access, Equity, and Diversity, and she's about to be on the board in July as the treasurer of the association. We really want to thank her for her many contributions to AAAED. Last but certainly not least is Mr. William D. Smitherman Sr., who is president and CEO of Absolute Mediation and Arbitration Services. We've also known Bill for a long time, as he served as the Pacific Regional Director, Pacific Region for the Ofccp, and he is, as was Mr. Bush, a member of the Senior Executive Service. Mr. Smitherman also specializes in mediation, ADR, and he has a Bachelor of Science degree in Labor Studies from Indiana University. Now, our agenda for today's webinar will give you an introduction to the field, to the issue of contract compliance as related to construction. And understand that this is an introduction. It gives you an overview of the field, but the real training will come in our classroom training. We urge you to sign up for that, because it really is worth your time. It is worth the time because no matter how many compliance reviews vary from administration to administration, you don't want to be the one who's selected. And if you are, then you need to know what to do about it, how to comply and let the government move on to other worthy contractors. We are here to help you comply with the law. Our agenda includes, again, the regulatory authority of Ofccp under Executive Order 11246, which it covers federal and federally assisted construction contractors and subcontractors. We will also talk about what happens during an Ofccp construction compliance evaluation, and that's really important. We will discuss the results of recent compliance actions by regions and what statistics and trends tell us about compliance readiness. And importantly, we'll talk about the steps learned from Ofccp settlements. Of course, you probably know, but we're going to underscore the impact of non-compliance, which can be debarment. And over the years, there have been debarments, especially with respect to construction contractors. We'll talk about the steps a company can take to mitigate those risks. And the high-level overview will provide of PDTI's, our 2018 EEO and Affirmative Action Construction Training, which is the classroom training. We'll, of course, have questions and answers. Let me also mention that we do on-site training as well as classroom training. You have only to contact Sandra or me. We will let you know our contact information, and we can bring the training to you. With that, and no further ado, I give you Mr. Harold Bush.
Good afternoon, everyone. Thank you, Shirley. I won't make any comments because I am probably the most senior person in many ways on this call, at least on our side. What I want to do is draw your attention to the current slide, and I'm just going to highlight some important points. Obviously, I'm not going to read it to you. One of the things that I've learned over the years is that the most important regulation and directive for those of you involved in construction and non-construction is actually the one mentioned in the first bullet point, the FARs. That's what they're known as, the Federal Acquisition Regulation. The reason I bring this to your attention, because this is the key to what we're going to talk about in a short minute on the next slide. The important point here I want to bring to your attention so you keep that in focus is that one should pay attention more to the nature of the contract, federal assisted construction work or direct federal contracts. We're going to talk about that over and over again, more than the type of company you are, because the key of this whole presentation and your responsibilities and obligations as a contractor relate to the nature of the contract, not whether or not your company, quote, is a construction company or a supply and service company. So you can see these points are made, and I want to emphasize that item behind the charts. Next slide, please. Next slide. We're good?
You're good.
Okay. This is a list of the executive orders and the origin of the executive orders. I think it was important to note that, as I mentioned, that the obligations of a contractor are not just related to the Executive Order 11246, but the Executive Order 11246 was the key to the contracting relationship. One of the things that you'll notice in the regulations is some of the changes over the years. I draw your attention to the executive order during the Johnson administration, which is very important to historical purposes. One of the reasons is it points out the obligations of a contractor, which we'll discuss over and over again, and that is to not discriminate and to take affirmative action. The origins of this executive order stem really from contract law, not just civil rights law. And that's important to remember because Ofccp's origin and employees take that role very seriously. The other thing you want to pay attention to in this chart is some changes. Obviously, the executive order was in 1978 by President Jimmy Carter, at that time, Executive Order 12086, took the agency, which previously all the contracting agencies were in the individual procurement offices of, say, GSA, Department of Transportation. But in October 20th of 1978, they all were consolidated under the Department of Labor. And that has caused the changes or the differences that you see today. I won't spend much more time on this because we'll be going over and over again. But I think one important point that I like to make as a sort of an historian in this area is the key to the whole concept that President Johnson, ex-President Johnson, made when he signed the executive order. He is quoted as saying, "It is not enough to allow minorities to be on the starting line of a race. What must be done is we have to ensure that they can finish the race." That is really the concept of affirmative action that we'll hear about for the rest of the day. And I think it's important to recognize that. And we'll talk more later. I'm going to turn this over to the next person, and Sandy's going to do that. And I appreciate your time.
Hey, thank you, Harold. Okay, so we have our first poll question, and that question is, which of these numbers represent the total financial settlement resolving discrimination alleged by OFCCP in fiscal year 2017? So if you would take a moment and make your selection. Okay, we'll give you another second here. Got about 71% that have voted. All right, we're going to go ahead and close our poll, and we're going to share it. So we see 70% say the 23,910,884, which is the correct answer. And we're going to talk more about the remedies that OFCCP might seek should they find discrimination later in the session. At this point, we're going to go on to our next slide. So if 23,910,884,000 were financial settlements, what were the groups affected by that? Well, the first group, number one, were blacks. The second group are males or whites at 23.7%, Asians, Pacific Islanders at 22.9%, females at 20.8%, and Hispanics at 4.60%, and Native Americans at less than 1% are disabled. We will actually take a look at a particular case later on in the session. So with this, I am going to turn it over to Bill.
Well, good morning. I would say good morning to those of you who are on the Southwest to Pacific region, and good afternoon to some of you who are on the other side of the Mississippi River. It is a delight for me to be here with you this morning. Thank you so much for signing up for this particular workshop and webinar. We hope that we both gain from the information that we're about to share with you. I think many of you on this call are familiar with the Office of Federal Contract Compliance Programs. The slide that you see before you, to your very right of that slide, has checkpoints on 5 items that occur under the authority of the OFCCP. There's the compliance or the non-compliance. Then there's negotiation, and when that fails, then there is debarment or ultimate sanctions. One of the things that I believe that many of you are aware of is that the OFCCP is in contact and does work closely with other groups, federal groups and organizations, such as the Women Businesses Program, and is very much involved with the Bureau of Apprentice and Program Training to promote opportunities in recruitment and selection for apprentices in the construction industry. Some of the things that we're going to continue to talk about throughout this particular webinar are the regions themselves, their location, the district offices that follow them, and the process by which contractors and subcontractors are reviewed, if you will, which would include the pre-award compliance reviews, full desk audit, on-site audits, complaint investigations by race, gender, and other protected reasons. One of the other things that I wanted to mention here too is the top two violations for OFCCP with contractors seems to be record keeping and recruitment. As you see before you now on the screen, there's a detail of each of the 6 offices that OFCCP has jurisdiction. As was mentioned before, I was regional director over the Pacific region in San Francisco for a number of years. Some of the things that were of extreme interest to me as a regional director in not only carrying out each of the orders that you see before you on the screen, was also the way in which compliance reviews were conducted, and moreover, the way in which construction compliance reviews were conducted. Now, for many of you who have had the opportunity to be selected by the OFCCP for an audit, you're familiar with pretty much the detail of what takes place on an audit. Some of those things, as I mentioned before, would be the on-site and compliance checks, looking at your records, checking to make sure that you have indicated and demonstrated good faith efforts in all of your employment practices. Next slide, please. As you know, and as I mentioned before, in just a few years ago, 2015, the OFCCP celebrated its 50th anniversary of the executive order. And in doing so, it again began to emphasize and talk about the achievements under the various parts that you see on your screen of that particular executive order, which deals with many of, if you'll notice, the outlines of race, religion, color, sex, orientation, and so forth in government contracts and government contracting. Next slide, please. These government contracts include individuals who are doing business with the federal government, of course, and all subcontractors and subcontractors under the executive order. And that also covers those subcontractors who have, under the executive order, $50,000 in contracts or employ 50 or more employees. And for federal construction subcontractors and subcontractors that have contracts of $10,000 or more fall within the jurisdiction for review of their good faith under the executive order. Next slide, please. What is a government contract? Well, again, many of you have experience about what a government contract is, but let me call your attention to what's ahead of you on the bullets. You'll notice that it means what it says in regard to modification between contracting agencies and persons for the sale, purchase, or use of personal or non-personal services. If you notice that the non-personal services also includes utilities, construction, transportation, etc. I mention those because utilities, transportation, and construction are the cornerstones of each other. In other words, construction touches both of those, as does the rest of those items that are listed under personnel or non-personnel services. Next slide, please. Under this slide, we talk a little bit more about what it means and the construction federally or federally assisted contractors. One of the things for those of you who love to take notes, especially from these kinds of webinars, I've got something for you to write. And that is part 3, section 301 and 302 of the executive order speaks to non-discrimination provisions in federally assisted construction contracts. And for a more detailed description about federal and federally assisted contracts and contractors, I would refer you to that or reading at your leisure. At this point, I'd like to turn it over to our next participant, and that's Harold.
Thank you, Bill. Again, we're following up on some of the regulatory concepts and requirements. And of course, as you see the slide in front of you, you see the 3 particular areas we're going to focus on. It's important here to remember what Bill has just mentioned, the distinction between federally assisted and direct federal contracts. And we're going to talk about that more and more as we proceed. The first item on my slide on your left is regards the EEO clause of the 2 obligations, non-discrimination and affirmative action. And as you can see, what you have on these slides is a jurisdiction for each one, paying attention to number 1, the number of employees and the size of the contract. I will tell you up front that the Ofccp website and regulations are a little bit behind what actually are the requirements. So we'll follow through on that, but some of the requirements in terms of the thresholds have changed, and that is an important factor. Number 1, as you see in the clause should be included in all your contracts and subcontracts, and obviously in all your advertisements for your company. An executive order threshold starts at 10,000 with no minimum number of employees. And for the Section 503, which is the Rehabilitation Act, and the Vietnam Era Veterans Act, VEVRA, the thresholds are 15,000 and 150,000. Some of that will change, and there will be updating. But as I mentioned to you, the key here is that the clause is a requirement in all your contracts and subcontracts, and your procurement officers in the government should be discussing that with you. The area that causes the most confusion is the middle slide, your EEO and Affirmative Action Development and Implementation. And construction contractors are required with $50,000 or more, there are requirements that change. One of the things, as you notice, is for the executive order, the threshold does not involve the number of employees, and the dollar amount is $10,000. So it's important that all of the affirmative action, all the obligations regarding the executive order are in a very low dollar range. That possibility of that being raised higher, $50,000 looks like it's going to be the minimum, but that's for further discussion. The only companies that have to concern themselves with developing an executive order AAP is dependent upon whether or not they are direct or federally assisted. Those companies that are direct federal contracts, in other words, maybe a federal building working on a military base, etc., they have requirements that would, if they meet the employee threshold and the dollar amount, would require written AP similar to the supply and service contractors. And we're not going to discuss that here, but you should be aware of that. The reason I raise that point is if you pay attention to the yellow highlight, you will see the requirement to develop and implement AAPs for federal contracts in construction. And it's very important to realize that unlike the supply and service under the executive order, there is no 30-day period that you have after you get the contract. your AAPs can be requested immediately. And that is important to realize that here right away, you could be in a non-compliant situation if you can't produce that. There is a letter, of course, which we'll talk about later, the process of a review, but it's important that you recognize here, and you also can see the dollar amounts. And again, the employee issue is not a factor. Access, the third slide, the third element in the slide on board talks about access. And I think we can really go to the next slide. Thank you, Sam. The important point here is that access for the entire employment process, whether it's at the site itself or at your headquarters, there has to be access for individuals with disabilities and individuals who are veterans with disabilities. And I think the important point you want to see here is that even if you don't meet some of the thresholds of Ofccp or executive orders, there are requirements under the American with Disabilities Act. And of course, that is our sister agency. We have a memorandum of understanding, and we do joint reviews at times. But the important point here is that no matter what, as long as you have 15 employees, there are requirements under the ADA that you have to be aware of. And I think it's important that you examine your sites and recognize, and Sandy's going to talk in a few minutes about the affirmative action steps, but this is a key. As employers, you must ensure that number one, there's access, and number two, you invite applicants to request a reasonable accommodation, and that you consider that accommodation and provide it as appropriate. I'm not going to spend a lot of time on this. I imagine we'll have some questions later. Sandy, it's your turn.
All right. Thank you.
Mm-hmm.
All right. I just bear with me here. Here we go. All right. So I'm going to talk about the 16 steps. And what you see on the slides are really a brief overview of those 16 steps. I want to mention there are also other requirements such as participation rates or utilization goals and how they're measured. There's also a requirement to notify Ofccp within 10 days of an award of a contract. While today companies are submitting them via email, fax, or snail mail, the Ofccp has recently put out a change on that, has proposed a change on that, and that is to have construction companies put them into an online contract award portal. And so, we'll see where that goes. So the contractor is required to take those 16 steps and to ensure equal employment opportunity as well as affirmative action. The evaluation of the company's compliance with these specifications is really based upon what they actually have documented. Construction industry is very different than supply and service in that documentation is key. If you don't have documentation, of course, with many enforcement agencies such as the Ofccp, they can infer that wrongdoing can be established. So it's very important. So I'm just going to, run through these fairly quickly. Ensure and maintain a working environment free of harassment, intimidation, and so on. And we're going to look at a case in which EEOC and Ofccp were signatory to a case, and it involved harassment and what actually occurred there. Establish and maintain a current list of minority and female recruitment sources. Again, you're not just, you need to maintain that. Maintain a current list, a file of the names and addresses of off-the-street applicants. You're required to notify the Ofccp when the union or the union impedes the process. You have to develop training opportunities, disseminate the company's EEO policies, Make sure that you use the EEO tagline in any of your advertisements. Direct your recruiting efforts to minority and female organizations. You have to conduct inventory and evaluation for promotional opportunities. Ensure the facilities and activities are non-segregated except for single-user washrooms. Document and maintain a record of all solicitations or offers for subcontracts from minority and female suppliers and vendors. You're going to conduct a annual review of supervisors' adherence. So it's very key. And so I will just put in a plug for our training in May that will go in great detail. That once you leave that session, you will have in hand how to comply with each of these requirements as well as the additional requirements. And with that, I will turn it over to Harold.
Thank you, Sandy. This is really a quick slide because the next few slides that Bill will present will go into some detail on the individual obligations. But again, this slide indicates what is required under the executive order or EEO clause. And again, the first two items stress the importance of the first obligation not to discriminate. And it also indicates, has added gender, sexual orientation, gender identity, or national origin. I draw your attention to the most recent, of course, is sexual orientation and gender identity. Also, it also explains the whole concept of what is involved in the clause. It's all personnel action, starting with recruitment, upgrading, demotion, transfer, and so on. I'm not going to go over each one. And the requirement to post the clause. It is very important. This is in the review process, the existence of posting and the existence of the clause and knowledge of it is a key factor in the conduct of a compliance review or audit by Ofccp. So you're setting the tone for your review. And I'm not going to spend any more time on this because Bill's going to give you some detail on the clauses and the meanings of EEO and affirmative action. Bill?
Hi, thanks, Harold. I think some of you on the phone probably know this pretty much like the back of your hand. But for those of you who are new or who have questions, one of the things as we defined equal employment opportunity, you can read for yourself. I'll just highlight in the red, is affording the same opportunity to all qualified persons regardless of protected reasons as you see. And the affirmative action requirement also means taking a look at your good faith efforts in how you write and carry out your procedures under the executive order and under your normal operations. As you also notice in construction, and I'm really going to try to talk about that a little bit later on, but just to whet your appetite, I'm going to touch on a few things that are misnomers and some things, as I said, are to me are gaps, what I consider to be gaps between the scheduling letter that a contractor receives, in this case, construction contractor, the on-site and the exit. They're all time consuming and things do happen in between those things that do take place. I won't get into the nitty gritty, but I'll touch on some of the things that some of you may have wondered about as we go through these. The next slide, please. The definition of a mega project, and for those of you who are contractors or subcontractors, it's pretty involved in this case. It's simple, but it's easy. And before you see these bullets that indicate what it qualifies you as a participant under a mega project. And normally, if you'll notice at the bottom in red, there are prime and subcontractors who work on these particular projects. So they're valued at $25 million or more. They last a year or more or longer. And they're in all regions that Ofccp has jurisdiction in all types of construction they're in. One of the things I want to share with you, in a report of August 2016. At that time, the Ofccp had 35 open mega construction projects that were distributed, across 6 regions and 24 district offices, and that's almost half of the field offices. The projects range from 25 million to over 5 billion, and the duration of these projects lasted anywhere between 1.5 years or a year and a half up to 35 years. And you ask yourself, what kind of project would go on for 35 years? Well, for those of you who are contractors, I think you'd love to have a contract with a mega project that lasted that long. I know I would. And they have had a value totally across the board, and that was then, of $29.5 billion. So as we both know, and as we all know, I should say, that's pretty lucrative. And as you take a look at those things that happen within that process, it calls to question, so what do I need to do? If I'm a contractor, what should I do? And I'm going to talk about the tiers a little bit if we have time. But there are prime and subs. And as you well know, the prime generally heads up, or it could be primes that are together, that come together in a joint project that is a humongous amount of money and capital being put up front. Then there are subcontractors under those contractors. And then there are tiered contractors under the subcontractors. And so it can go anywhere from a first tier to a third tier contractor. And when it gets down to first, second, and third tier, that might touch some of you that are on the phone now that are maybe 5 to 7 person operations, maybe 15 people working within that framework of a mega project. You're still required under the contractor to still maintain and demonstrate good faith efforts in all your hiring practices and procedures and your recruitment procedures. So I'll talk about it a little bit more, and I hope you have some questions about this as we go on. Thank you very much.
Yes, yes, thank you, Bill. One thing that leads into the next slide, which is the different steps in the compliance review. I just want to mention that and reiterate something that Bill said, and something that occurred during the Clinton administration when I was at the national office with Shirley as our director, and I was director of operations. The key to remember on a mega project, and it's going to come up as we talk, is one of the reasons the agency developed the mega project concept was the difference between a mega project and a regular construction review is the fact that in a mega project, there is much more control for predicting the flow of work, i.e. the crafts that are coming on board, the subcontractor. And I want to emphasize that this is an area where your affirmative action steps are really important, because you can start out in most mega projects with problems in recruitment and hiring, and you can actually pick up a covered person and develop them through the apprentice program all the way to a trade classification, because the lifetime of the contract is so long. As you know, all know, the bidding process requires that you have not only a plan to bring on the different companies, subcontracting plan, but also requires notification regarding the different crafts that are coming on board. So I just want to emphasize that that is why it's a win-win for Ofccp as it is for you. But let's look at the review process. And the slide is pretty clear. I think what you don't see here, it's important to know, is that EEOC, which I call our Ofccp sister agency, and Ofccp have an MOU, a Memorandum of Understanding, since 1970. So part of the process before an actual on-site review is scheduled is to look at and share information through the agencies. And that's part of the process of every single review. So it's important to realize that regardless of whether or not you have a formal complaint at that time, the Ofccp will examine the process, and it is considered a joint recognition of the jurisdiction. If you look at the steps, I think, and I'm getting ready to go to the next slide, but just pay attention to the fact that you're going to have a very quick process. There is no 30 days to submit an AAP. The letter will identify the date at the coming on site. There will be some off-site analysis prior to coming on site, as you see, and then they will go through all the different aspects of not only looking at what you said you did, but looking at the documentation and so on. They'll also look at your past compliance history. And this is important because it all will lead to the not only the step of compliance review report, but the notification. Let's go to the next slide.
Harold, if I could.
Sure. Okay.
Just a quick comment. If you go back to that slide, please.
Sure.
Thank you. As Harold said, one of the things that as a regional director and Harold being in Washington with policy, one of the things, operations rather, one of the things that's important that I noticed about construction compliance reviews, as Harold brought out, is bullet number 2, sub number 2, the review of records, and more importantly, the identification of discrimination. Oftentimes that's passed over or overlooked because contractors feel that, well, we've not received a complaint or we haven't heard from EEOC, so we think we're okay in the treatment of our employees that are protected under 11246. Later on, we may discuss, and certainly in our face-to-face training next month, we're really going to go into that a lot more. I'll close by simply saying on this slide that under the last bullet, notification of compliance results, to negotiate a resolution or enforcement, that is key. And many of you have received a letter of compliance, perhaps in construction or perhaps in service and supply. Well, when that occurs, the checkpoints are you've done what you are supposed to do in regard to Executive Order 11246. And I will simply say that in many cases, many of you who are doing things right, don't get me wrong, may have escaped the scrutiny of an experienced compliance officer that knows where to look for these kinds of problems that you see can develop in a construction work site. And under enforcement, under 60-1.26, if you take a look at that and look at what 126 and 127 says, it talks a little bit more about enforcement and debarment. And so we want to stay away from that altogether if we possibly can. So thanks, Harold. I just wanted to throw that in.
No problem. Going to the next slide, and I'm going to emphasize some items even from the last slide. Again, I want to always do this because we're talking about construction, that it's very important to keep in mind the differences between a direct federal contract and a federally assisted contract in the review process. As I said, you're not going to get a 30-day to submit an AAP. In most cases, you're going to get a letter telling you they're coming on site. And the point I wanted to make here is that in the federally assisted construction, they are subject to 11246, but not VEVRA or 503. However, in those companies with direct federal contracts, their entire workforce, including those not involved in the construction end, in the trade workforce, their records and reviews of those records is possible and can be done because of jurisdiction. So it's very important to recognize that Ofccp has a much larger jurisdiction than you might first appear. And we'll talk about this later when we probably answer some of your questions. Now we're looking here on this slide, it says indicators that will lead to a compliance review process. And as already emphasized a few minutes ago, the inquiries from the EEOC and other state civil rights agencies and local agencies, any type of record with the vets, which is part of the Department of Labor, regarding your treatment of veterans or disabled veterans, and so on. This is all going to be part of the assessment and part of the process. And of course, during the review, there may be an opportunity, and this becomes a problem on some construction sites. Believe me, I know, as Ms. Wiltshire had mentioned, we have a lot of experience here. I think if you add it all up, it's over 100 years, not for one individual, though. And knowing I had to go into the tunnels when they were building the subway in New York, and I can remember trying to conduct interviews in the tunnel is a lot of fun. But if you look at the different bullet points, you'll see that every aspect of the employment process is examined. They're also looking at trends in terms of utilization. In most cases, it's going to be the trades here, and mega projects is the actual project, well, the covered area is certainly still jurisdiction. And they're going to look at your records and what records you have. And this can be problematic. One of the things, as Bill had mentioned in mega projects, and I mentioned, is the fact that you do have prime contractors in a mega project and other projects who can assist in this area of record keeping on site. And I just want to stress the importance of that as you move on in the review process. These are all things that are looked at. Employee interviews are a key factor. And again, compensation, if they're being paid properly. Those of you in union and non-union situations understand that you could have a different pay wage in the non-union process, where a person can actually be a laborer in the morning and a craft person in the afternoon. So these are all the factors, as well as your good faith efforts. I'm going to now move over and turn the next presentation back over to Sandy, and she's going to discuss non-compliance procedures.
Thank you, Harold. Okay, Ofccp non-compliance procedures. So you see the various elements on the slide here. We'll start with the predetermination notice. It's really a letter in which Ofccp notifies the contractor of its preliminary findings that the Ofccp is alleging that the contractor has engaged in a pattern or practice of discrimination. And it's just what it says. It's a preliminary findings. This gives the contractor an opportunity to respond. And as many of you who are familiar with the Ofccp, they recently issued a new directive. Actually, it was the first directive under the new director on the use of the predetermination to be used in all cases. Historically, this was only used in systemic cases. It is now used in individual and systemic cases. The next item, here's a notice of violations. When Ofccp conducts a compliance evaluation, compliance review, if they identify violations of the regulations, the company will receive a notice of violations and therefore afforded an opportunity to respond. That notice of violations will include, what the violation is, along with the remedy, followed by conciliation agreement. That will include reporting provisions. Anytime you enter into a conciliation agreement, there are reporting provisions. So what does that mean? The review is not over. And sometimes those reporting provisions can go on for 1 to 2 years or longer, depending upon how long the Ofccp believes that it will take for the company to come into compliance. The show cause notice. Show cause notice can be issued at any juncture, particularly if the company has failed to provide documentation that has been requested. It's really a letter from the Ofccp to the contractor ordering it to show cause why enforcement proceedings should not be instituted. Then we have, the 15-day notice, where the Ofccp believes the company has violated a conciliation agreement. They will be given 15 days to address why they did or did not comply with all the required elements of that conciliation agreement. If all else fails, negotiation, resolution, then the OCCP will seek administrative complaint, followed by debarment. And I know when Ms. Wilshire was the director of OCCP, she initiated term debarment. Shirley?
Yes.
Would you like to just talk briefly about that term debarment?
Harold probably remembers better than I do, but
Okay.
we go ahead. I mean, I remember when I came, we had started that, and we were able actually to debar a couple of companies.
Yes, we were.
Construction companies in particular. You want to talk about how that worked?
Yes, I think let's go back to the slide for a minute, and I think it'll help put in order. Up to the third from the bottom bullet point, the 15-day notice, a company is not in the enforcement stage. Conciliation agreement is part of the ending or resolution of violations, starting with record keeping and lack of good faith, up to and including discrimination or compensation issues. Once the 15-day notice is issued, that is an indication that the agency, as Sandy mentioned, is going to, as in the enforcement stage. And what the short-term or debarments were is in many of the companies that we were reviewing at that time, we went through the entire process. We are now at the conciliation point, ready to issue the administrative complaint and go into possible litigation. And we were able, the companies agreed to, in most cases, to a limited term debarment. The point is that is a significant enforcement initiative. Those companies and the officers of the companies were then prohibited for that period of time from having any federal contracts. They couldn't change their names. They couldn't sell the company to their wife or their husband. They were debarred from getting any more federal contracts. Could even affect their current contracts, depending on the discussion. So we used in the agency, we use this in not that many cases, but a significant number of cases for the first time. Basically, most of those cases, except for one, which my memory is not a construction, but for the construction ones, in most cases, the companies agreed to resolve the violations with a limited term debarment. I mean, that clearly is a punitive damage situation and a penalty. And I won't mention all the issues. All those involve discrimination, and the companies in some cases were recalcitrant in trying to resolve it during the earlier part of the conciliation.
Oh, thank you, Harold. I just want to add to this, and thank you, Shirley. On that debarment, it actually has a domino effect. As Harold mentioned, you know, as a federal contractor, you cannot do business with anybody who's not in compliance. So if you are debarred, that means perhaps your vendors and suppliers may not do business with you if they are involved in government work as well. So it has a really kind of a long-term effect. Okay, our next slide here is another poll question, and we're going to go ahead and launch that. And it has to do with the average number of days an OCCP compliance evaluation is open. Okay, so if you would go ahead and make your selection. Okay, we're going to give it a few more seconds here. Okay, we're going to go ahead and close it, and we're going to share the results. And so, as you can see, 19% said over 900 days, 19% also said 720 days, 44% said 45 days, and 19% said 30 days. The correct answer, the average number of days without discrimination is 720 days. Although I will mention that the new director in one of his speeches recently mentioned that many of the audits are more than 1,000 days old, with some even running longer. So it's really important that if you don't have things in order, it could certainly extend the audit. All right, Harold?
Yes, thank you. I think, as you can see the slide in front of you, that it's interesting we just followed the concepts related to violations and the steps. Now you have a chart in front of you which shows you the types, in this case, the number of reviews, construction reviews from fiscal year 2007 through 2017, the number conducted, the number in violation, and their actual percentages of violations. As you can see, reading from right to left, that the number of reviews have gone down over the years, but the percentage of violations has actually increased. Overall, the range from 41% of the reviews, or 41.3, all the way up to 56.6 or 57%. I will want to mention here that as Bill had mentioned and Sandy has indicated, that the violations, really a lot of them for the conciliation agreements, which is going to be the next slide, and Sandy, you can go over to that. The key here is that a lot of the violations, which we'll talk about a little later, and this is just a regional breakdown of the conciliation agreements, meaning that there was a violation of some type. And certainly you see the Pacific region had the highest percentage. But I was going to point out to you that one has to recognize why and how a company may get to that point. And in getting ready to introduce, I believe the next person is Sandy again. She's going to talk about the type of violations, but I think it's important here to realize that failure to provide accommodations for women workers, equal facilities, shower, bathrooms, whatever it is, failure to document and take your affirmative action steps are all evidence that relate to how a company is found in violation. And certainly it's something to be concerned about, because as you saw, 720 days for non-violation, you do the calculation if you've come back to life after that figure and realize how much time and energy and money is being spent because you have not prepared yourself beforehand and complied with the regulations. Sandy, I'm going to turn it over to you.
Okay, thank you. All right, so this slide, you're able to see the types of violations by region. As we know that recruitment has typically been among the top 2 violations cited by Ofccp, but for construction, it's pretty consistent. Followed by that is record keeping. Again, because record keeping in the construction industry is so critical to your compliance status, your compliance profile. So you want to make sure that you do maintain adequate records and that type of thing. Past performance, and depending upon the region that you're in, it could be a prior agreement that you entered into with the Ofccp, or it could be you failed to achieve your participation goals as well as other affirmative action obligations. Written affirmative action plans definitely would be the Section 503 and VEVRA, but also could be some of those required affirmative action steps as well. And then compliance other would be all other kinds of violations that aren't cited elsewhere. for example, harassment, that type of thing. And alleged hiring, it is what it says it is. It's hiring discrimination. But I will give you some stats here on the kinds of violations for construction for fiscal year 2017. We talked earlier that 56.6% were all violations, but Executive Order 11246, which is really the meat for all construction contractors, was at 55.7%. And as you've seen on the earlier slide that Harold talked about, it's been pretty consistent at or above 41.6%. So you want to make sure that if you are obligated to comply, you know what to do and when. All right. So I'm going to turn it over to Bill now.
Hi. I'm back again. I don't know about you, but when I talk about taking good faith effort and moving ahead and advancing and really demonstrating positive affirmative action and equal employment opportunity decisions in your companies, I get a little bit excited about the prospects. One of the things that I wanted to say to you as we take a look at slide 29 is, and you've heard this before, you don't know what you don't know. And that is just not a catchphrase, it's true. Because each of these bullets that you're taking a look at, if you don't have a grasp on them, then you don't know what to do or how to prepare yourself. The impact of noncompliance is and can be very devastating. As we talked a little bit about getting up to and debarment. But what's more devastating than, I just made a note back on the slide, I guess it was 23 or 22, 700 days for a compliance review to be open. I don't know about now, particularly with each regional office who has capable staff and leadership. I don't know what that means in each area. I know that when I was regional director, I had taken a look and I worked with my managers and others around us, and I did training over and over again about how to eliminate downtime. And that's what I called it, downtime. And that can lead up to these staggering figures, and even sometimes even more. No, we didn't get it all right. And yes, there were some times that we did exceed 1,000 days for other actions that led to administrative law judge intervention and other things. But I want you to understand that here, when we take a look at what the risks are and what's involved, look at bullet 3. It affects the company's bottom line. And after all, many companies, whether you're in the Fortune 500 group or in construction, and you're still within the leadership, or you're just making sure that you're successful in taking on these government contracts, that knowledge by other individuals in your trade that you're not in compliance or you have been found in non-compliance can often set you back when you're being considered by a prime contractor. Now, I'm talking plain here. I'm talking to those of you who are in construction already. You know how arduous that can be. Do you have time to keep up the records? And you got one person wearing more than one hat that's keeping up with your books and having to do these things. And all of a sudden you get this letter and here comes Ofccp. And what stands out for you is 120 days. Well, my gosh, you can't take that kind of time away. And so what do you do? Well, one of the things that you're doing right now is taking the first step, and that's being on this call. Second step is to pick up on our construction training later next month, where we really go into some of this information. Now, I'm adding this in with these slides and bullets that you can very easily read yourself, because I wanted to say something to you about the gaps. I talked to you about the gaps before that lead to these kinds of things here. And those gaps happen as a result of a lack of follow-through and preparation on both sides of the compliance review process. It happens with contractors who, because of the fact of what you're trying to do and making a profit and maybe staying functionally, as a successful business, it comes when you don't compile records or you don't keep the records, or some things and decisions that were made that you didn't know about or perhaps were informed about later were not necessarily the right ones that caused you a problem. Well, to the other side, Ofccp, that's a green light. We're at a smorgasbord. So if you're talking about making absolutely certain that you keep yourself from running into these financial liabilities and the lack of morale on the job sites that you have, or certainly within your employment opportunities, and the negative press, who wants to see their company in all these reporting processes that has been indicated one way or the other that has to do with something that's going on. Also, as I turn to something I want Sandy to talk a little bit about with the case that you see underlined, is that there are many reasons why these cases stay open that long. And I have 15 top reasons that will tell you why that happens. And I'll give you a kibitz. One of those reasons is the failure to demonstrate good faith effort in your record keeping. And it ties into everything that Harold and Sandra have said before. So as Sandra talks about it, take a look and see what this says to you and how it affects you and your business. Sandra?
All right. Thank you so much. All right. So we're going to take a look at this conciliation agreement here. And this is coming right in from Ofccp's website, the Foyer reading room. So this is what a conciliation agreement looks like. And in this particular case, which is not the norm, but it does happen from time to time, both EEOC and Ofccp were signatory to this case. This case actually started, and we talked a little bit about timeliness. This particular case started in February of 2011. So really the various sections of the conciliation agreement, as you can see, part one, the preliminary statement, that's Ofccp's preliminary statement. Then we have part two, Ofccp general terms and conditions, typically otherwise referred to as the legalese. And then we get into the violations. Ofccp specific violations and remedies. Okay, so in this particular case, and this happens to be a construction company, they did not ensure and maintain a working environment free of harassment, intimidation, and coercion at all of their work sites and in all facilities where they had folks employed. So this is where the EEOC actually got involved, and in this case, there were punitive damages. The rest of the violations that you see here are technical violations, record-keeping violations, and again, when I say technical violations, associated with the construction industry. And so you're able to go into this and take a look at your leisure once you get the slides. But there's something else I wanted to point out, and that is, and here's the EEOC's provisions, their terms and conditions were also incorporated here. The damages, there was a damage award of $100,000. They also had to hire a consultant, appointment of an EEO coordinator, which was mentioned earlier. It is a requirement under the construction regulations that every contractor identify someone responsible for the EEO and affirmative action. They went on to identify what the responsibilities of that coordinator were. And this particular case closed in 2016 once the parties agreed, and then they had to submit progress reports. And the progress reports, the last report was due May 15th of 2017. So as you can see, it's quite extensive here. And certainly the case was open for many years. It, I believe, opened, what was that? February 11, 2011. So I just wanted to share that with everyone because it does take a toll on. All right.
Sandra?
Yes.
This is Shirley. If I could just add, because you asked me about term debarments, and that's been more than 18 years ago, so you'll have to forgive me. I had to refresh my memory. I do remember one of the reasons why we did that was because ordinarily when there are settlements or even debarments, you know, if the contractor shows it's in compliance, everything goes away and you get back to the status quo ante. For the term debarment, we wanted a contractor to be debarred for a period of time. So that in that regard, the debarment was what it was supposed to be. And not only for future contracts, but existing contracts. That was the goal. Now, it sounds pretty punitive, and we're not here to be, beating the drum regarding a sanction. It's actually quite rare, but more often than not, at least in my experience, it happened in the construction industry. So, but I did want to answer your question more fully. It was to make sure that at least the debarment stuck for a period of time, like 6 to 12 months. I believe the agency still has that authority. We actually did try to codify it, and there was some pushback. But that was the point. So, but the bottom line is never to get that far. And that's the whole point of this training, to indicate that you can help yourself by taking these kinds of trainings or letting us help you. This is something that's doable. So you can get on with the business of construction. Let's work out and let's figure out how to get the compliance piece done so that you can go ahead and do the job that you were hired to do.
Yeah. If I can add something, Shirley did a great job. And I just want to take a look at, for a minute, look at on slide 29, the last bullet point, last two really, talking about new business opportunities and negative press release. During Shirley's time at Ofccp, we had what we called an egregious list that actually was a press release at one time. It was stopped early in the next administration, but if I'm not going to go into details or criticize anything that was done by any director or any administrative team, but this case is an example of what could have been classified as an egregious case. I know some of the details of this case for my professional reasons. I can tell you that they were very lucky. In many of the cases, and particularly in those that we sought limited term debarment, for the reasons that Shirley mentioned, the officers of the company were mentioned in the agreements and in the press release. Their names were used. And in this case, as in other cases, there's a good chance when that happens that, particularly with EEOC, that individuals who were aggrieved in some way and were discriminated against come forward in this process while the review is ongoing. And I'm not sure in this case whether that happened or not. I did see a language requirement for the EEO coordinator be fluent in both English and Spanish. So you see 60-50, you see national origin, you see a lot of other potential violations that would have possibly led to, in previous administration, a limited term debarment discussion and suggestion.
Okay. Thank you, Shirley and Harold. Okay. We are, got a few more slides here. Bill?
Yeah. Thank you. Thanks very much. I appreciate it. One of the things I want to call everyone's attention to as we take a look at contractor lessons learned. My goodness, there's a ton of things that each of us learn not only from the standpoint of having a review, but also preparation for that review and training in making sure that our workplace is one in which we are following the requirements of the regulations. Under this, items 1 through 6, I have an asterisk there if you notice on 2, what I consider to be the most overlooked violations that cause concerns for companies as they go down the road to compliance. And while they may not show on your screen, they are recruitment and record keeping. Over and over again. How many times have you heard it said? How many classes have you sat in? How many teachings have you given about those two subjects? One of the things and one of the reasons I think they're so pervasive is because while the techniques are given and while the information is handed out in the form of documents, one of the things I think happens is the theory behind this. I liken this when I talk to people about record keeping and recruitment is a couple of things. It's like using your cell phone. If you have your cell phone and you kick it over to calculate, and you've got a number that you want to take a look at and you want to come up with really quick, and right now you're just not coming up with that mentally, you punch that calculator. Well, it gives you the number. But if you don't know how to add or subtract, basically, then while you got the right number, you don't know how you got there. And that's one of the other things we talked about here. You don't know what you don't know. So in this case, one of the things that it says there, if you look at the 5th line, it begins with defend. Be prepared to defend. Why? Why should you put yourself in the defensive mode? One of the things that I like to explain to contractors and those practitioners is that you're not defending anything that you've done. You're taking an opportunity to express and demonstrate the good faith efforts that you've taken. You're talking to people who are coming in to visit your place of business. You want them to think and to leave with the thought and understanding that this is a good place to work, that there are people who are satisfied in being gainfully employed at your shop, that you are on top of the rules and regulations, and that you're doing what's necessary to continue to work and be productive and supplying jobs for America's workers. As we go further, those two, not so much past performance, but those two are what I consider to be caveats. Let me again refer to the note takers. If you take a look at the EEO clause under 60-4 and at 60-437, I want to let you know that with the things that are happening currently around you, and all the construction work is being taken place because of the horrible conditions we've had with weather and coastal flooding and hurricanes and storms, there's an infrastructure repair. There are going to be a number of opportunities for you as contractors at some point in that contract to demonstrate your qualifications as a business. So if you take a look at documenting and maintaining records of all solicitations to subcontractors from minority and female construction contractors, suppliers, and associates, that's going to be a big area. And that's going to be a big concern. And how do you do that? And what do you do? Well, in our training coming up next month, we'll talk about that. We'll talk about how to set up the steps that make those things happen. We talk about the backup that you need, the performance information that you need to supply any contractor or I should say compliance officer that comes in to take a look at your workforce. You want to, at this point, as a contractor, you want to be in a position that you can feel good about the services that you supply. So let's not look at defending what you do. Let's herald what you do as being the right thing under the regulations to do that. Thanks.
Thank you, Bill. All right. I just want to, this next slide, these are some steps to take to mitigate your risk, and I'm not going to go through them as you can read for yourself, but our plan is for the training. We will go in more detail, but the bottom line is what you don't know really can hurt you, and sometimes we don't know what we don't know until it's too late. And that's all that I'll say on that. I also want to mention this next slide, the DOL and OFCCP transparency. I want you to do use Chrome if you do go in there. But this is the transparency now that has come about over the past several years. The Foyer reading room is where you can go in and read all of the Ofccp conciliation agreements involving financial liability. Ofccp by the numbers really speaks for itself there. The class member locator is fairly new. It is a place where if Ofccp is a finding of discrimination and there are victims they believe to be out there, this is where folks can tells them who to contact and where. And then, of course, the DOL enforcement database. And with that, I will turn it over to our executive director.
Okay, thank you, Sandra, Harold, and Bill or William for this very informative webinar. We hope that it was informative, but I hope it also interested you or helped you to understand the importance of working with us, either on site or in our classroom training, to really focus on getting your ducks in a row, being prepared if you get the call. But let me also say, this is more than about paperwork and compliance. This is about an equal opportunity workplace in the era of Me Too and a lot of other things going on. This is not worth the pain. Non-compliance is simply not worth the pain. So let us please work together through training or other kinds of means to provide advice and counsel on this area. We believe we are the only organization that has moved to do this kind of training for the construction industry, and we really truly are here to work with you. Please be in touch with us and let us know if you want us to come on site or if we can help you otherwise. As the slide indicates, the kinds of training that's going to be included and was touched on in this webinar. The location of the first classroom training will be next month, May 9th and 10th, at the offices of Metra, 547 West Jackson Boulevard in Chicago. We're going to extend the registration just because it's so close to this webinar, but please take advantage of this. We look forward to seeing you. Sandra, if you have anything else to close out?
I just want to thank everyone for their participation today, be it the polls, the presenters, Shirley, Harold, and Bill. This has been a great opportunity to actually share some of our knowledge, and we hope that you will join us for the May session. With that, I know we had a couple of questions here. I believe we've covered most of the questions that have come in. One question, though, was asked, what kind of accommodations would a construction contractor make? Again, that's going to be based upon the individual circumstances, but typically, the construction contractor may not necessarily be covered by Section 503, but they would be covered by the Americans with Disabilities Act. And so you'd have to take a look at the individual situation. I can just think of one right now. So, and while this may not be a tradesperson, but this may be somebody who's working on site in a trailer, and that is where their office is on the project. Let's say you have someone in a wheelchair, and you just really need to make that process accessible. So again, you have to look at it as an individual situation and what's reasonable for your organization. So with that, thank you all. We hope to see you in May in Chicago. Thank you.
Goodbye.
Goodbye.